Imagine, like, a referee who can just rewrite the rule book while the game is actually being played.
Right, which sounds completely unfair from the start.
Oh, it gets better. They also get to handpick the umpires, who will eventually succeed them, and the players. They are practically forbidden from ever firing this referee.
Yeah, I mean, that doesn't sound like a legitimate sporting event at all.
Exactly. It sounds like a rigged casino. But in reality, that is the actual structural design of one of the most powerful judicial systems on Earth.
It really is a remarkable setup. And, you know, it raises this really fundamental question for any democracy.
Right.
Like, how do you balance the absolute necessity of the rule of law with the messy, ever-shifting reality of political power?
Welcome to the deep dive. Today we are exploring the Indian judiciary, specifically focusing on the Supreme Court of India.
Yeah, we're pulling from a really detailed chapter in an Indian political science textbook called Indian Constitution at Work.
And just to be clear, this isn't going to be some dry legal lesson. Our mission for you today is to understand how this institution evolved to hold such massive authority.
Exactly. And how its quest to protect democratic ideals often puts it in direct, sometimes incredibly dramatic, conflict with the very government that appoints it.
Okay, let's unpack this. To really understand how this judiciary wields its power, we first have to look at its armor, right?
Yes, the armor is crucial.
Yep.
Because the foundational concept of any modern democracy is the rule of law.
Right, the idea that all individuals are subject to the exact same legal standards.
Exactly. Whether you're a billionaire industrialist, a rural farmer, or, the prime minister themselves, but for a judge to actually enforce that against powerful people, they need an ironclad shield.
Because if a judge is worried about getting their budget slashed or losing their pension just because they ruled against a sitting politician, they're naturally going to hesitate.
They'd have to. So the Indian Constitution builds this armor in a few very specific ways. First, judges have a fixed tenure.
Meaning they hold office until they reach a mandatory retirement age.
Right. There is no hanging threat of losing their job over a single unpopular ruling or, like, a shift in the political winds.
That security of tenure is essentially the baseline. But the second piece of armor is just as critical, which is financial independence.
Yes. The salaries and allowances of these judges are charged directly to what's called the Consolidated Fund of India.
Wait, meaning their paychecks are not subject to the annual approval of the legislature?
Exactly. Politicians cannot quietly defund the judiciary by squeezing their operational budget just because they didn't like a recent verdict.
Wow. Okay, that structural separation makes perfect sense. But there is a third piece of armor, and this is where it starts to feel a bit like a superpower.
You're talking about contempt of court.
Yeah. The judiciary has the authority to penalize people for contempt of court. This is designed to protect judges from unfair criticism.
Right, and the parliament isn't even allowed to discuss the conduct of judges on the floor of the House unless they're in the middle of a formal removal proceeding.
It's just such a sweeping power. But, when you hear that a judge can punish you just for criticizing them, your first instinct is probably to think, wait, isn't that just a dictatorship of judges?
Yeah, I totally see why you'd think that.
Like, if they are financially independent, essentially immune from being fired, and have the power to punish their critics, who holds them accountable?
What's fascinating here is that this is the exact danger built into the system. Because independence, in the context of a democracy, cannot mean arbitrariness.
Right. They can't just do whatever they want.
Exactly. The judiciary isn't an island. It's an integral part of the democratic political structure. So it remains ultimately accountable to the Constitution and to the people.
But navigating that exact tension-granting judges the absolute independence they need while maintaining accountability is the central drama of this text.
It really is. And because a judge is essentially untouchable once they are seated on the bench, it completely shifts the battlefield.
Right. The intense political warfare naturally moves to the hiring and firing stages. So let's look at the hiring part first.
Historically, there was a very clear convention for appointments. The senior-most judge of the Supreme Court was practically always appointed as the Chief Justice of India.
It was a simple, predictable escalator. You just wait your turn.
Exactly. But then, in the 1970s, the political branches decided to completely disrupt that escalator.
And that disruption was highly controversial, right? Like in 1973.
Yes. The government appointed Justice A.N. Ray as Chief Justice, deliberately superseding 3 judges who had seniority over him.
Oh, wow.
And then it happened again in 1975 when Justice M.H. Beg was appointed over Justice H.R. Khanna.
So these were not just administrative oversights.
No, not at all. They were widely viewed as calculated political moves to reward judges who were perceived as sympathetic to the ruling government.
And to punish those who were not. They were basically trying to stack the deck.
Exactly. But the Supreme Court didn't just accept that political interference. They fought back.
And they did it by fundamentally altering the mechanism of how judges are hired. They established what is known as the collegiality principle.
Right, the collegium system. It was a brilliant defensive maneuver.
How does that actually work in practice?
Well, the court ruled that the Chief Justice must recommend names for appointment, but they can only do so in consultation with a group of the 4 senior-most judges of the court.
So they essentially formed an exclusive internal committee, like a private club.
Basically, yeah. The executive branch still formally makes the appointment, but the judiciary gave itself the dominant hand in deciding whose names even make it onto the list.
They insulated themselves by taking over their own HR department.
That's a great way to put it.
But if the executive branch's power to hire was curtailed by the collegium, we have to look at the legislature's power to fire.
And the removal process is where this constitutional design gets truly put to the test.
Right, because removing a judge requires proven misbehavior or incapacity, and it demands a special majority in both houses of parliament.
To understand how nearly impossible this is, you really have to look at the 1991 Ramaswamy case.
Yes, the first ever motion to remove a Supreme Court justice in India.
Exactly. Justice V. Ramaswamy was accused of misappropriating funds while he was serving as the Chief Justice of the Punjab and Haryana High Court.
And this wasn't just a rumor. A motion was signed by over 100 members of parliament.
Right, and a high-profile inquiry commission made up of sitting Supreme Court judges investigated the whole thing.
And they didn't just find circumstantial evidence. The formal inquiry found him guilty of willful and gross misuses of office.
Yeah, moral turpitude for using public funds for private purposes.
So you have a formal inquiry of his peers declaring him guilty, but he didn't lose his job.
No, he didn't. He actually survived the removal motion on the floor of Parliament.
Wait, so an official inquiry found him guilty of misusing funds, but he kept his job. How?
The mechanics of how he survived are fascinating. To remove a judge, the motion needs a 2/3 majority of the members who are present and voting.
Okay, that makes sense.
But it also requires an absolute majority of the total strength of the House.
So what happened?
During the vote, the ruling Congress party decided to abstain entirely. They didn't vote against the removal, they just sat on their hands.
Because they abstained, the motion failed to cross that dual lock threshold.
Exactly.
Wait, so because a political party basically chose not to show up, he kept his job? Doesn't that prove the politicians still hold the ultimate trump card?
Well, it proves that the framers made removal almost unimaginably difficult. It reveals this really complex balance of power.
The executive hires, the legislature fires.
Right. But to actually pull the trigger, they need near-unanimous consensus across fiercely divided party lines. The system prioritizes institutional stability, even if it occasionally protects a guilty individual.
Wow. Okay, so they are practically impossible to fire, and they manage their own hiring. With an invulnerable roster like that, what does their actual playing field look like?
Well, unlike the United States, which has this fragmented system of separate state and federal courts, India utilizes a single, integrated pyramidal structure.
Right. At the very top sits the Supreme Court of India. Its decisions are absolutely binding on all other courts.
And below it are the high courts in the various states, then the district courts, and finally the subordinate courts.
But the Supreme Court isn't just a court of last resort, right? It has very specific jurisdictions. Let's walk through those. First is original jurisdiction.
Yeah, this means the Supreme Court acts as the exclusive umpire for federal disputes.
So if the national government is in a massive legal fight with a state, or if 2 states are fighting each other, say, over river water, they bypass the lower courts entirely.
Exactly. They go straight to the Supreme Court. Then there's appellate jurisdiction, which is the highest court of appeal for civil and criminal cases.
Which is what most people think of. But the third power, writ jurisdiction, is where the court directly touches the citizen.
Yes. Writ jurisdiction is the mechanism for enforcing fundamental rights. It empowers the court to issue specific orders, like habeas corpus.
Let's translate that for you listening, because it's a term thrown around in legal dramas all the time. Habeas corpus literally means produce the body.
Right.
It means the government cannot just lock you in a dark room and throw away the key. They have to physically bring you before a judge.
Exactly. And another critical writ is mandamus, which translates to we command. This is used when a public official is simply refusing to do their legal duty.
So the court steps in to force them to act.
Right. And if a citizen's fundamental rights are actively being violated, they don't have to spend a decade climbing the judicial pyramid. They can appeal directly to the Supreme Court.
But then there is a fourth power called advisory jurisdiction. The President of India can ask the Supreme Court for advice on public matters.
Yes, but the catch is that the Supreme Court is not legally obligated to answer.
And even if they do, the president is not legally obligated to accept the advice. This sounds like me asking a friend for outfit advice, them refusing to tell me, or me completely ignoring their suggestion anyway.
That's a funny way to put it, yeah.
What is the actual point of this if it's entirely optional for everyone?
If we connect this to the bigger picture, it's actually incredibly useful. Think of it like running a software beta test.
Okay, I'm listening.
Imagine the government wants to pass a massive economic reform, but they fear it might contain a hidden constitutional flaw.
Right.
Instead of passing the law, waiting 3 years for a lawsuit, and then watching the Supreme Court strike it down, which wastes billions of dollars, they run the idea through the Supreme Court first.
Oh, it's a legal temperature check.
Exactly. It prevents messy legal battles later on, and it allows the government to quietly tweak laws before officially launching them.
That makes a ton of sense. So having these formal powers is one thing. But what happens when judges decide to stretch their legs?
Well, this absolute security is exactly what emboldened the Supreme Court in the late 1970s to completely revolutionize justice in India.
Right. They shifted from just waiting for cases to arrive to actively democratizing the legal process through judicial activism.
And this marks a profound turning point. Prior to this, you could only approach the court if you had been personally directly aggrieved.
So if your property was stolen, you filed a case. But in a country with massive poverty and widespread illiteracy, millions had no means to hire a lawyer.
To fix this, the court introduced public interest litigation, or PIL. They fundamentally changed who was allowed to knock on their door.
They allowed public-spirited citizens or journalists to file cases on behalf of the poor. Here's where it gets really interesting.
The pioneer cases are extraordinary. In 1979, a lawyer read newspaper reports detailing the horrific conditions of undertrials in Bihar.
People locked up awaiting trial for longer than their maximum possible sentence.
Exactly. The lawyer filed a petition based purely on the newspaper articles, and the Supreme Court accepted it. This became the Husainara Khatun case,
which led to the release of tens of thousands of prisoners. And then the very next year, in 1980, an inmate in Tihar jail managed to scribble a desperate note about physical torture.
on a scrap of paper, yeah.
He smuggled it out to a Supreme Court justice. And instead of throwing it away because it wasn't on proper legal stationery, the judge converted that note into a formal writ petition.
That became the Sunil Batra case. It was a radical shift in judicial philosophy. Justice P.N. Bhagwati explicitly argued that the poor need a different judicial approach.
Because if they forced the vulnerable to adhere to rigid procedures, they'd be denying them justice.
Right. But this proactive approach inevitably has a dark side. The courts became massively overburdened.
And it blurred the lines between the branches of government. Under PILs, the courts started taking on executive tasks.
Yes, like ordering slums to be removed for city beautification, or managing corruption investigations like the Hawala case.
Right. I mean, it's amazing they read a scribbled note from a prisoner. But ordering a municipality to clean a slum or investigating politicians, aren't they stepping out of their lane?
That is the exact danger highlighted in the text. They are judges, not mayors or police chiefs.
They don't have the administrative expertise or the democratic mandate to run a city.
And the framers anticipated this. Aladi Krishnaswamy Iyer, a constituent assembly member, explicitly warned that the judiciary shouldn't become a super legislature or super executive.
It really forces you to ask, would you prefer a slow, proper elected government or a fast, overreaching court making all the decisions?
It's a tough dilemma. And this tendency of the court to expand its territory naturally led to a massive collision with the parliament.
A constitutional turf war was inevitable, and the defining battleground was property rights, wasn't it?
It was. The newly elected parliament wanted to enact sweeping land reforms to redistribute estates from wealthy landlords to landless farmers.
But the court said no. They ruled that Parliament cannot restrict fundamental rights, and property was a fundamental right at the time.
Right, so the parliament tried to bypass the court by simply amending the Constitution itself.
And this escalating war culminated in 1973 with the Kesavanda Haradi case.
Yes. A massive bench of 13 judges convened to resolve the limits of Parliament's amending power, and their ruling was an absolute masterpiece of judicial strategy.
It was basically a constitutional sleight of hand. First, they agreed that the right to property wasn't actually basic and could be abridged by Parliament.
So the government got exactly what it wanted on the land reform issue. But, and this is the turning point, the court simultaneously established the basic structure doctrine.
Right. They ruled that Parliament cannot pass amendments that violate the basic structure of the Constitution.
And crucially, the court reserved the sole right to decide what actually constitutes that basic structure.
Wait a minute. So the court gave the Parliament what they wanted on the property issue, but in exchange, the court effectively gave itself the ultimate veto power over any future constitutional amendment.
Yes.
That's not a compromise. That's a brilliant power grab.
It is a profound observation, and you are absolutely right. The basic structure doctrine fundamentally changed the relationship between the two branches.
It ensured the court remains the ultimate interpreter of the Constitution.
Exactly. It successfully checked legislative supremacy once and for all.
So what does this all mean? We started by looking at a unified pyramid of courts, protecting rights through tools like PILs.
Right.
But we also saw how this institution constantly dances on the edge of becoming a super legislature in its battles with Parliament.
It's an incredible journey. But we want to leave you with one final thought to mull over.
Yeah, go ahead.
We've seen that the judiciary invented the basic structure doctrine to place limits on the Parliament's power to change the Constitution.
Mm-hmm.
But if the judiciary is the only body allowed to define what that basic structure is, and judges essentially appoint their own successors through the collegium system,
Right.
who, in the end, acts as the ultimate check on the power of the judges? Think about that next time you read about a major Supreme Court ruling.
That is a fascinating question to leave on. Thank you so much for joining us on this deep dive. We'll catch you next time.